For judgment item 1, WPS 6155 of 2010.
This repetition is allowed.
Yeah.
One particular message.
For final disclosure item 2, criminal vision 587 of 2015.
Your lips by praying for short passover. Mr. Sumit Prakash is in court number 2.
Court number?
4.
Parvati. You have come? बारह बजे होगा पासवर्ड. आप सुन लिए?
छोटा सा प्लेयर
किसके साथ?
सेकंड
हाँ बोलिए.
उसमें पहले विजय कुमार सिन्हा कर रहा था लॉर्ड ही हैज डाइड, तो मेरे पास फाइल नेम लॉर्ड्स अगर पीडीएफ लेने के लिए.
आप सुमित प्रकाश.
जी मैम.
आपके पास फाइल नहीं है?
मतलब विजय कुमार सिन्हा ही पहले कर रहे थे,
तो ये लाइए जरा फाइल दिखाइए.
तो पीडीएफ एक बार में लॉर्ड्स मिल जाता तो हम कर देते उसको.
यही फाइल है. आपका पिछली बार तो आपने ऐसा नहीं बोला.
मतलब
आपके
पिछली बार हम
काउंसिल ने बोला था आप पूरा दिन फाइल पढ़ लीजिए. 1 बजे तक फाइल पढ़िए, 1 बजे सुनेंगे.
सेकंड हाफ कर दिया.
सेकंड हाफ दूसरा बेंच. यू कम एट 1 o'clock.
कंप्यूटर में अवेलेबल है.
आपके कंप्यूटर में भी अवेलेबल है.
पूरा एलसीआर पूरा देखना होगा.
देखिए भाई आपका काम है. आप ही के
बस इसको
कहने
कल-
पे आज हम लोग रखे. कल नहीं होगा. देखिए इस तरह से नहीं होता मैटर. You have enough time. 10:45 है अभी. I am asking you to be there at 1 o'clock. You go through that.
थोड़ा सा मतलब नहीं समय मिल पाएगा इस पढ़ पाने का इसको, इसलिए खाली कह रहे थे इसको कल क्लियर रख दिया था, कल कर देंगे. खाली पीडीएफ क्लियर कर दिया आज. थोड़ा सा मतलब खाली हम्बल रिक्वेस्ट.
तो वो पासओवर के लिए क्यों प्ले किए? ये बोलना चाहिए था ना उनको. Mr. Sumit Prakash
यस मैम.
appears and submits that he has not gone through the brief. He prays that the matter be posted tomorrow. Counsel for the state is present. Post this case tomorrow to be taken up at 10:30 sharp.
बस पीडीएफ के लिए.
हम लोग नहीं देंगे पीडीएफ. आप अपना देखिए. रिकॉर्ड है आपके पास. आप अपना देखिए. दैट इज नॉट आवर बिजनेस.
एक हम्बल रिक्वेस्ट हो जाता तो
क्या हम्बल रिक्वेस्ट है?
एलसीआर पूरा मतलब देखना.
एलसीआर का पीडीएफ हम आपको नहीं दे सकते हैं ना. किसी को नहीं देते हैं. एलसीआर तो आपको यहीं पे बैठ के देखना है.
ठीक.
एलसीआर है, इनको प्रोवाइड कर दीजिए.
ठीक.
किसी को नहीं देते हैं.
ठीक.
Item 3, criminal vision 260 of 2016 along with item 4.
There is a petitioner. इसको पासओवर. इसमें किसी को माइक से बंद करना पड़ेगा. If the council does not have. ये dismiss for default भी कर सकते हैं. That is also possible. हाँ बात. अभी पासओवर करो. पहली बार में DMT नहीं कर. हाँ 12 बजे.
Item 5, criminal vision 1430 of 2016.
ये इसी से रिलेटेड है, एक ही केस से अराइज कर, इसको भी पास हो गया।
Okay. Item 6, Criminal Division 1494 of 2016.
Yes, petitioner.
Yes, ma'am. In this case, Lordship, order dated 22/8/2016 is under the challenge, where the appellant has been sentenced under 337 of the NPC and 279 of the NPC. Except, Your Lordship, the informant of the case, Lordship, none of the passengers was traveling on the vehicles which felt an accident, stated that the appellant was driving the vehicles. He was also present in the dock, but none of the passenger has identified him. And the informant has only stated during course of investigation that he has given this vehicle only to drive the appellant. Kindly see.
No, I'm not able to get your point. What is your point? Accident हुआ कि नहीं हुआ?
Lordship,
Accident happened or did not happen?
it happened.
Date
And
of
one
accident?
one passenger has also died.
Date of accident.
Date of occurrence was Lordship 4/10/2010, and FIR was instituted on 4/10/2010 itself. In the FIR, the owner of the
You were the driver?
Lordship,
So there is no dispute that you were driving the vehicle. Okay, what was the nature of vehicle?
Lordship,
What was the vehicle?
I'm not audible clearly, Lordship.
Sorry,
Not audible clearly.
you can't hear me. किस तरह का vehicle था? बस था, ऑटो रिक्शा था?
Lordship, passenger vehicles.
आपको हिंदी में बोलना है?
No, Lordship. Sound जो है ना थोड़ा सा कम आ रहा है मुझे.
मेरी आवाज कम आ रही है?
जी.
आपको सुनाई दे रही है? I'm very loud and clear.
मुझे थोड़ा सा कम सुनाई दे रहा है. Yes.
You should see a doctor then. Because my voice is otherwise I am very loud and clear. अब ठीक है? Am I loud enough?
No, Lordship.
I will be louder for you,
It was passenger vehicle, Lordship.
passenger. Okay. So what do you want to say? What is your point?
That is.
Yes, tell us.
Kindly see page 22 of Lordship, of impugn order, which is under the channel. Para 13, PW5 Lordship. All the PW has stated that he was not driving the vehicle, the petitioner, but except this, Ram Lakhan Barai, the owner of the Mahindra Geo auto bringing registration source, clearly disclosed that he is and he had handed over the auto to Samul Haq Ansari, the petitioner Lordship, for driving. Further, he disclosed the occurrence related to 2 years back of the 2011. He has given the said auto to accused 2 months before. Further, he identified that he had given his auto to the person standing in the dock, which is the Samul Haq Ansari. He proved receiving of the auto so and so. He has only stated that he has given his vehicles to drive to this vehicle 2 months ago, 2 years ago. But he has not stated anywhere that he was driving the vehicle at the time of the
Who
accident.
is Jagmohan Barai?
That's it.
Who is Jagmohan Barai? You read PW4. You read PW4. PW4 is a victim and also eyewitness to the occurrence. PW4.
PW
4.
Subhash Topo,
Yes.
informant. Para 9 of the 2, page number 21, Lordship.
Yes, you read it. I read it.
He was sitting in the auto and coming from the railway to Gumla and reached the Lohadak at the time. The auto driver was driving unceremoniously and anxiously, and due to that, the auto was turned on. Around 10 to 12 persons sitting in the auto gets injured, and he also received injury on his thigh back, left side. He is also received injury for which he was lying on the bed for 1 month. Further, he disposed that Buddhamaya, Sukram, Buddharam, etc. also sustained. They were the passenger lordship.
Yes.
Sustained injury during the cross of Buddhamaya Devi, who has died in the hospital.
Yes.
His evidence forwarded so and so of the Subhash Topo. They have all the witnesses have all the passengers stated that the vehicles was rising roughly and it is admitted and it comes in the course of the but no one has stated that this petitioner was driving the vehicles.
No, this is what it says.
Only one.
Driven by the driver.
Lordship.
This PW4 has not identified you.
No. He disclosed the restaurant was driven by the driver, not this petitioner or appellant lordship. None of the passenger was was traveling in the auto that felt accident lordship has stated that this petitioner was driving. Also in the dock lordship, nobody has identified this person inside the trial court lordship. Kindly, may I read the position of this PW4 lordship? Deposition, it is clear, lordship. Para 4 of the deposition of the informant.
Read it, please. Read
उस
it.
ऑटो का नंबर सो एंड सो था जिसको झांक कर चला रहा था वह अभियुक्त नाम नहीं जानते हैं उसके देखेंगे पहचान लूंगा अभियुक्त की डॉक में खड़ा देखकर
अभियुक्त को डॉक में खड़ा देखकर
हाँ देख के बोला कि उसका बाल बड़ा था लेकिन इसका बाल छोटा छोटा ही है मैंने इसे पीछे से देखा था मैं इसके ठीक से नहीं कह सकता हूँ यही वो व्यक्ति था
PW4 अपने चीफ में ही ठीक से
all the deposition laws everyone has stated like this statement
let
that
us see
nobody has seen that he was driving the vehicle at the time of accident.
let us see PW3.
PW3 घटना देखकर मैं सन 2011 की थी उस समय मैं अपने घटना के तक हमारा भूला हुआ था वन में तिलमिड़ी में गए देखा कि टेम्पो का
Who is the owner of the vehicle? PW?
PW
5.
5
PW5 for cross examination. the fact
In the
that he
first
has
paragraph is stated that एहतसामुल हक अंसारी भाड़े गाड़ी चलाने के लिए दिया था. This is owner of the vehicle also.
yes, yes.
He has stated चलाने के लिए दिया था before 2 months of the accident. But he has not stated also further anywhere that he was driving the vehicle at that time. This is
He
my
is
only
not an
point.
eyewitness. The point is that he has deposed that he had given you the vehicle for driving.
Only for driving. But at the time of the incident, Lordship, passenger was also he was carrying the passenger. None of the passengers identified, not stated in the doc that he was driving at the time of the occurrence.
You
Lordship.
have not
Owner
cross-examined him.
has also stated, never stated anywhere that he was driving the vehicles at the time of the accident. Lordship. Only he stated, it has kept that I have given vehicle to drive him, but 2 months ago the date of occurrence.
So what
It
is
is-
your explanation? Now it has been proved that vehicle was given to you for driving,
Lordship,
right?
it is admitted fact.
Then what is your statement?
I
under
was
section-
not flying the
What
vehicles.
is your statement under section 313?
I denied that I was driving the vehicles.
Okay, you denied, but you see, the vehicle was given to you by the
Last-
owner.
Last-
This is an admitted fact.
So my activity is that I took the vehicles and given to under somebody else for driving.
From where do I get this? Have you led any defense evidence?
No.
Then, from where do we see that you have
But
given?
Lordship,
From
the-
where do we see that you had given the vehicle for driving to somebody else?
that is it is not under the.
It is not there, so we will not
But-
see anything which is
but-
not there.
But the important thing is that the person who was traveling during
You
before
have
the
not
accident.
cross-examined him.
Nobody
properly.
has stated, Lordship. Nobody has identified me also in the documents. The benefit of doubt may be given to Lordship. But I am also one judgment related to that Lordship under the 401 and 397 Lordship.
397.
If there is a doubt
There is no
regarding
doubt. I have no doubt in my mind. You might be having many doubts. You have not cross-examined the owner of the vehicle properly, nor you have given any defense evidence. He has proved that the vehicle was given to you for the purposes of driving. You have not cross-examined him at all. Isn't it? You have remained in custody for how many months? What is your custody? No idea. 6 months. You don't know about your custody?
Lordship.
You don't
Custody.
know about the custody?
I was at the custody for
6 months. You were released on bail on 7.
31/17 and I got and it has been enlarged on bail on 7/2/2017. Lordship.
Sorry? Okay. What is your
About
custody?
8 years. I surrendered on 30th of the January 2017
2017. Okay.
and enlarged on bail by this honorable court on
17.
7th of the February 2017. Under the 337 Lordship, there is a provision of 6 months of imprisonment along with the fine, 1,000, and 279 3 months and up to 1,000 Lordship. Cost may be given Lordship. I may be enlarged on bail Lordship.
PW 1 and 2 also claimed that they could identify the driver. But on that day you were not present, on the date of their examination. PW 1 and 2 also said that they could identify the driver. Right?
Identify, but at the time of the identification.
You must be on representation. If you are personally not there, they will not identify your advocate, isn't it? That is the concept of a person being in representation, that he will not dispute his identity. If you are not there on the dock, then who can identify you in the dock? They have said that they can identify you.
I was present at that occasion. Once Subhas has also started.
What is the date of examination of PW1?
PW1 Lordship.
Yes. 16/8/2012. Right?
16 August 2012.
Okay, let us see whether on 16th August 2012 you were there or not. The order sheet will show.
Yes. It was 20th of November 2014. For the
16/8/2012. You are on representation. Accused has been represented, which is allowed for today. You were not there, that they could identify you on the dock. Isn't it? PW2 was also examined on the same day. And you were not there. PW4 was confused.
PW4.
And the driver of the vehicle has given the evidence that it was handed over to him. And there is no cross-examination on that point. Only one person died or two persons? Yes? Yes, counsel?
Lordship.
कितने लोग मरे? एक. One person died. One person died.
One person.
एक आदमी मरे हैं.
Lordship. She was Budhmani Devi. During the course of treatment, Lordship.
That's right. It was a bus.
No.
It was a
It was auto.
auto.
Public carrier tempo, जो
Okay.
diesel auto.
Okay, diesel. थोड़ा सा मुश्किल है. आपका सेंटेंस कुछ देख लेते हैं. कितना का सजा दिया है? What is the period?
One thing is also important, but in the consideration of 494-337 Lordship, IU has also
We are
not been
not bothered
examined,
about
and
the
neither
body.
the also has visited the place of occurrence, stated
It
nothing
doesn't make
about
any
that.
difference. You are not in denial of the incident. The incident has been duly proved. Now, whatever you have argued is not tallying with the records. Therefore, we have seen the records. On the day PW1 and 2 were examined, you were not there personally. You were on representation.
Some fine may be imposed upon me, Lordship. Now I am.
वही तो सजा कितना है देख रहे हैं तो पता ही नहीं चल रहा
6
पूरा.
months, Lordship. 6 months for 337 है. 277 79 में भी 6 months ही है.
And 304 में conviction नहीं है.
304 में conviction नहीं है Lordship. 337 में है, 279 में है.
337 में
पेज 37 में
आप जब पढ़िए पेज 37 में पढ़िए
Lordship.
37 पढ़िए.
पेज 37 में लास्ट पैराग्राफ.
हाँ is sentenced
that
to
witnesses
undergo
of the
RI
sub-
for 6 months for 337.
some simple injuries.
Hmm.
Hereby sentenced to undergo rigorous imprisonment for a period of 6 months for an offence of 337 of the IPC, and further he is sentenced to rigorous imprisonment for a period of 3 months for offence of 279 of the IPC. 6 months for the 337 and 3 months for the 279.
Is it your first offence? Is this your first offence?
Lordship.
पहला केस है आपका ये?
जी लॉर्डशिप। तो ही एग्रीमेंट में लेके चलवाते हैं लॉर्डशिप। इसमें वर्बल था लॉर्डशिप, एग्रीमेंट नहीं करवाए थे, वर्बल ऑटो लिया था चलवाने के लिए, and thereafter I have given to somebody else to drive. And I mean, after the 2 months of the vehicles taken, the accident, vehicle accident lordship.
Heard the learned counsel for the petitioner. Nobody appears on behalf of opposite party state. This petition has been filed against the judgment dated 22/8/2016, passed by the learned district and additional sessions judge Roman Dulla in criminal appeal number 63 of 2015, whereby the appeal filed by the petitioner has been dismissed. The petitioner has been convicted in connection with GR number 879 of 2011, arising out of CSI PS case number 158 of 2011, corresponding to TR number 266 of 2015, for offence under section 337 and 279 of IPC, and he has been directed to undergo rigorous imprisonment for a period of 6 months for offence under section 337, and further undergo rigorous imprisonment for a period of 3 months for offence under section 279 of IPC. The learned counsel for the petitioner, while assailing the impugned judgments, has submitted that though there are concurrent findings recorded by both the courts, the impugned judgments call for interference. The learned counsel submits that none of the witnesses have identified the petitioner as the driver of the vehicle, and the petitioner has been convicted merely on account of the deposition of the owner of the vehicle, who deposed that he had given the vehicle to the petitioner for hire for driving 2 months before the date of the incident. The learned counsel has further submitted that PW4, who is the informant of the case, upon seeing the petitioner, got confused with regard to identity of the driver. He submits that in such circumstances, the identity of the petitioner as a driver of the offending vehicle having not been proved, the petitioner is entitled for benefit of doubt. He has further submitted that without prejudice to the aforesaid submissions, the petitioner has remained in custody in connection with the case for a period of about 15 days. He had surrendered on 30/1/2017 during the pendency of this case and was enlarged on bail wide order dated 7/2/2017, and the bail bond was furnished before the court on 15/2/2017. The learned counsel has also submitted that the petitioner has been acquitted for offence under section 304 capital A of IPC. He has also submitted that the case is of the year 2011. Case was registered on FIR on 4/10/2011, and the petitioner has faced the criminal case for 14 years, and therefore some sympathetic view may be taken. He has also submitted that the vehicle was Maxi Cab Tempo, bearing registration number J80701850. After hearing the learned counsel for the petition, and upon going through the materials on record, this court finds that the prosecution was launched on the basis of Forgery of the informant, namely Subhash Toppo, within bracket PW4, on which was recorded by the concerned police officer on 4/10/2011 at Referral Hospital Sisai in connection with the occurrence which had taken place on 4/10/2011. The giving the detail of the tempo against the tempo driver bearing registration number J807D-1850. The prosecution case was that Subhash Topo was going to Gumla and he was standing on the road. In the meantime, one white colored tempo bearing, in the meantime, the said tempo came and he sat in the auto, tempo auto, and he alleged that the driver was driving the vehicle very rashly and negligently. And at National Highway 23 on the road, the vehicle turned down, due to which the passengers sitting in the vehicle got injured. With the help of nearby people, they were brought to the referral hospital. He has given the name of the persons who were treated in the hospital, but one victim died during the course of treatment. The petitioner faced the trial for offence under section 279, 337 and 304 of Indian Penal Code. At the stage of trial, altogether 6 witnesses were examined. PW1, PW2 are the victims. PW4 is the informant himself. PW5 is the owner of the vehicle, and PW6 is the doctor. PW3 is the owner of the hotel. The certain documentary evidences were also exhibited. The injury report of PW4, the injury report of the victims were exhibited as Exhibit 3 to 3/3. The learned trial court considered the evidences on record and recorded his finding in paragraph 17 of the judgment. From the perusal of para 17, it is apparent that PW 1, 2 and 4 had claimed to identify the driver of the vehicle. However, PW4 got confused with respect to the identity of the driver. It has been recorded that PW1 and 2 also claimed to identify the driver but on the day they were examined, the petitioner was not present in the court. This court has gone through the evidence of PW1 and 2, who were examined and cross-examined on the same day, that is on 16/8/2012. Both these witnesses have claimed to identify the driver and had stated that the driver was not present in the court on that particular day. The order sheet of the learned court dated 16/8/2012 reveals that the petitioner was on representation which was allowed for that particular day. Meaning thereby, the petitioner was not physically present on 16/8/2012 and was on representation. In such circumstances, the argument of the learned counsel for the petitioner that none of the witnesses have identified the petitioner is not correct. This court also finds that the owner of the vehicle had also deposed, and he had clearly stated that the vehicle was given to the petitioner for the purposes of driving on hire, and the said witness has not been cross-examined on this point. So far as in considering the totality of facts and circumstances and the materials brought from record, this court is of the considered view that the petitioner has been duly identified as the driver of the offending vehicle, who was driving the vehicle in a rash and negligent manner. However, and all the witnesses who were victims have clearly stated that petitioner was driving the vehicle in rash and negligent manner. However, the petitioner was not convicted for offence under section 304 capital A because of the reason that the death report of the deceased Budmani Devi, who was also a passenger on the auto, was not proved. And it has been recorded that although the postmortem report of the deceased was on record, but the same was not proved by the prosecution. The learned court has also recorded that orally all the witnesses had supported that Budmaniya Devi died during the course of treatment. The learned trial court was of the view that the prosecution could not conclusively prove the death of Budmani Devi, and hence the benefit has been given to the petitioner. The finding in that connection is recorded in paragraph 18 of the trial court judgment, which is as follows. The petitioner has been ultimately acquitted under section 304 capital A of IPC and has been held guilty for offence under section 279 and 337 of IPC. The petitioner has been given the maximum punishment. So far as this court, accordingly, the learned appellate court has also scrutinized the materials on record and has given concurrent findings with regard to the conviction of the petitioner. Having gone through the impugned judgments and the material on record, this court is of the considered view that the learned courts have given the learned court have given concurrent finding with regard to rash and negligent driving of the petitioner, and that the petitioner was the driver of the vehicle, of the offending vehicle. Accordingly, this court finds no reason to interfere with the judgment of conviction of the petitioner. So far as the sentence is concerned, the learned appellate court, while considering the sentence, was of the view that the sentence against the petitioner was sound and did not choose to interfere with the sentence. However, considering the fact that the petitioner has faced the criminal case for almost 14 years and has been convicted for offence under section 337 and 279 of IPC. This court is of the considered view that the ends of justice would be met if the sentence is modified to some extent. Accordingly, the sentence of the petitioner is reduced to 4 months, subject to payment of $4 months with fine of rupees. कितना फाइन है इसमें? 279 में 337 fine of rupees 500 under section 337 of IPC and and 1,000 rupees under section 279 of IPC. The fine amount be deposited within a period of 15 days from the date of communication of this judgment. Bail bond cancelled. Distribution is disposed of.
There is only fine provision of our lordship.
आपको एक बात बताएं,
Fine may be
your acquittal under section 304 is also erroneous. ठीक है, चलिए और कुछ बोलने का हमको जरूरत नहीं.
Item 7, Criminal Division 1364 of 2017.
14 साल हो गया है, थोड़ा सा और जेल काट के निकल जाएंगे. Yes, petitioner, are you there? Yes, madam.
This is the case of section 16, subsection 1, clause AI of
Here is the
arbitration.
opposite party state. We'll have to hear the state in this case, not without the state. You have prepared your note? Yes. Where is your note?
At this point of time,
You have not typed it.
no, I didn't have typed. I just written it down.
Criminal Revision number 1364 of 2017. Counsel for the petitioner seeks adjournment. ये सब बिना note के कैसे होगा? See, you have to. On the last date also, I asked you to prepare some note on this. Give us some note.
I have prepared it on. I didn't have typed it. That's why I have written it down.
Please type it out. Please type it out. इसको टाइप करिए. नहीं आता है टाइपिंग? आप बस करिए. इसको टाइप करिए. ऐसे हम. I want to see your note because I know that you are absolutely a new counsel so far as, and this topic is also slightly different from the regular IPC matters. So therefore you need to prepare it. The sections you are referring, the notification you are referring, please prepare it. I just give a date, you prepare it. Okay?
Next week.
हाँ कोई नहीं, next week नहीं होगा. अब छुट्टी के बाद होगा. Post on 14th October. In the meantime, the petitioner shall prepare a short note in connection with the points raised in the proceedings and submit the same by 4th of October.
Item 8, Revision 1397 of 2017.
Yes, petitioner.
Only 50%.
On last occasion, ADC has ordered to has call for the orders of the appeal.
Yes, it has come. Order sheet of appeal.
जी, क्योंकि इनका केस ये था कि वो प्रोविजनल बेल पे थे,
हाँ.
बट फॉर्म हुआ था कि नहीं,
हाँ.
उसके लिए मांगा गया था.
You have not deposited the special messenger cost. Yes?
There was only instruction to take possible.
You have not?
Mr. Classic Circle will
Yes, yes, yes. I know. You have not deposited the special messenger cost. बताइए. We'll dismiss this case because there is no option. क्या करें बताइए? You'll have to surrender. We'll set aside the order, but you will have to surrender. बुलाइए हमको. आज से कल नहीं होगा ये. ठीक है?
पासपोर्ट 12:30.
पास हो. 12 बजे.
12.
Item 9, Revision 1722 of 2017.
Yes, petitioner. You're the amicus in this case.
Yes, Lordship.
Are you the amicus
Yes,
in this
yes,
case?
I am also.
Argue, please.
Yes,
What is the matter?
Lordship, the petitioner has been convicted under section 498A. A complaint case was filed by his wife, namely Badki Marandi, where she has
Complaint case, just a moment. (498) capital A. Okay. Complainant has been examined as
a complainant witness number 1.
CW1. You read the prosecution case and CW1.
In her complaint, she has mentioned that
Para 1 of the trial court judgment.
yes, the case of the complainant, as per the complaint petition, in short, is that 4 years ago, a marriage was solemnized with Mandal Murmu as per Santhali ritis and rituals, and thereafter she went to her sasural, where initially she enjoyed happily married life for a couple of years, and during that period she became blessed with a female child. The complainant has stated in her complaint petition that for the last year, the accused persons started doing altercations with her, and after depriving her daily meals, they were also used to assault her. It is also case of the complainant that at the time of filing of complaint petition, she was having a child in her womb, but the accused persons were not looking after her, and after taking possession of her daughter, he deprived the complainant out of her matrimonial home. The complaint petition states that the accused persons were not interested in keeping her with the husband as planning to perform second marriage, and lastly that the complainant was dropped by her husband in Khijiri village, from where he ran away after leaving her in Lod.
There is no allegation of any demand.
No, Your Lordship. There is no allegation of demand of any kind of dowry, and Your Lordship, the defense witnesses also in their depositions have stated that there was no assault of any kind upon the complainant from the side of the husband. Your Lordship, in para 20 of a cross-examination, which is a very relevant para, Your Lordship, that she has stated and admitted that जमीन के लालच के कारण यह झूठा केस किया है. In her cross-examination, she has stated.
Para number 17?
Para number 20.
20. Let us see the finding of the trial court. Kindly read the finding.
Your Lordship, the complainant witness number 1, which is Badki Murmu, who is the complainant, she has stated that after the husband made her leave the house, the sasural of the complainant, and she has mentioned that after that she went to her parental house, but Your Lordship, the complainant witness number 2 has stated in
She has stated that CW2 has stated that मारपीट के बारे में हम नहीं जानते.
yes, Your Lordship.
Right? This is what you want to say.
Yes, Your Lordship.
In his cross-examination,
And Your Lordship, the complainant witness 2 also states that after marriage she was at her sasural for only 1 day, which is a wrong statement, Your Lordship, because she has stated in her examination that she was happily married for first 3 years, and after that the husband started assaulting her, and he was willing to marry a second.
let us see the findings of the court. How the court has convicted. Para 12,
Yes, sir.
you read para.
It is very clear from the testimonies of the complainant CW1, Badki Murmu, and CW2, Dharodhar Marandi, who is the uncle of the complainant, that the complainant was evicted from her marital home by her husband Mandal Murmu after the birth of her young child, and after lapse of some time, her husband also performed second marriage with a girl of village Dagra. The witnesses examined on behalf of the defense, the defense witness 1 Sukhdev Soren and defense witness number 2 Simon Soren have also stated that the accused Mandal Murmu had performed second marriage. In para 8 of DW1 and para 5 of DW2 are relevant in this regard.
आगे बढ़िए.
In the view of this fact, it becomes crystal clear that being neglected by her husband Mandal Murmu, the complainant was forced to take shelter in village Hijari, which appears to be a mental cruelty. In our society, a girl dreams of great days ahead with hope and aspiration, where entering into a marriage, and when after some time in her nuptial relationship, her husband refuses to keep her and kicks her out and performs second marriage. There cannot be any larger mental torture, harassment, or cruelty for any bride.
He was not charged with 494.
No, Your Lordship, only 498.
Only 498.
Earlier, the complaint was filed along with 323 also, but the charge has been framed only under section 498.
Read para 5, 15. Read para 15.
Yes, Your Lordship.
Para 15 of the title.
So far as the charge framed against the accused, Kalami Marandi, who is the mother-in-law of the complainant, under section 498A of IPC is concerned, the statements of complainant Badki Murmu, CW1 and Dharodar Marandi, CW2 fails to show even a visca of evidence against her. None of these evidences has spoken.
The name of the girl with whom the second marriage was performed has come?
Yes,
Evidence.
it is not recorded, Your Lordship.
Let us see the appellate court judgment. You come to the appellate court.
Your Lordship, the girl's name is Malho Soren. In para number,
Yes.
in her cross-examination, the cross-examination of CW1, it is mentioned, Your Lordship, in para 11.
Para 11.
No, Your Lordship, para 30.
Para 30.
Malho Soren, daughter of Manji Soren of village Dagra. But Your Lordship, here the complainant has stated that she went.
Recently married.
Yes. At the
So
time
at the
of
time of deposition, she
she
they
came
got
to know
married.
that he has performed.
On the at the time of complaint, this marriage was not there.
No, Your Lordship. No, Your Lordship.
When was she examined?
He at the time of complaints, Your Lordship, she has mentioned
There was an
that
allegation that he is likely
he is
to.
willing to marry.
Yes.
He performed second marriage.
And subsequently, he got married.
Yes, sir.
And therefore, there was no question of any charge under section 494.
No.
Let us see the appellate court's judgment. Yes, you are for the state.
I am for the opinion, madam. I am
You
also
tell
an
us.
amicus.
You tell us. 498A case was instituted. Admittedly, there is no demand of dowry. Firstly, the assault has also not been proved. It is only a case of mental cruelty. She was thrown out of her matrimonial house while she was pregnant. The courts have convicted her on the ground that she has remarried. At the time of filing of the complaint, he had not remarried, right? And therefore he has not been, neither any charge was framed for 494, right? then how he can be convicted for offence under section 498A for any act which he has done after the institution of peace. देखिए 307 का केस हुआ, उसके बाद जाके डेथ हो गया, वो तो इट इज सीक्वल ऑफ द सेम इवेंट, राइट? तो 302 में चार्जशीट हो जाता है और 302 का चार्ज पेश कर, इसमें तो चार्ज ही नहीं हुआ, सेकेंड
494 का चार्ज नहीं
चार्ज नहीं हुआ एंड इट इज द सब्सिक्वेंट इवेंट.
but my lord, I have judgment passed by this honorable court where marrying second time during the subsistence of a valid marriage is mental cruelty.
बट 494 का चार्ज नहीं है.
My lord,
And at the time the complaint was filed,
he was not
married. So how can this conviction be sustained? There could be another case for 490.
my lord.
But this,
I was also thinking that why 494 has not been added.
because it is a subsequent event. They could have altered the, we do not know whether they could have altered the charge or not because it is a subsequent event. आज मारपीट हुआ 307 का केस हो गया. उसके बाद 5 दिन बाद फिर मारपीट हुआ और 302 का केस हो गया. तो 307 का केस के साथ 302 तो क्लब नहीं होगा ना. Not sustainable.
498 का तो इस हिसाब से
कोई केस नहीं बना. चलिए, when was CW2 CW1 examined? Did she make an allegation in the complaint that he has married again?
No, Your Lordship. Only that he is willing to marry.
He is willing to marry.
And Your Lordship, I want to add one more point, Your Lordship. In her cross-examination, she has stated that after she was kicked out of the house by her husband, she went back to her matrimonial home. The parental home. But Your Lordship, the defense witness number 1, Sukhdev Soren, in para 2 of his examination, he has deposed that this witness has clarified that the complainant was not staying in her parental home, rather she has been living in the house of some other person.
this has also come in the records. She is living
Your
with some
Lordship.
other person.
This other person is not related to this complainant, Your Lordship. And she was having a love affair, Your Lordship, though she was living with him.
किसी अन्य के यहाँ रहती.
Although this marriage was also a love marriage between the parties. Also.
This was also a love marriage.
Yes, Your Lordship.
This witness has been cross-examined, not cross-examined. हाँ है.
In Your Lordship, the defense witness number 2, Simon Soren, has also stated
You see,
in para.
did you cross-examine the complainant on this point?
No, Your Lordship.
If you have not cross-examined, बाद में defense देने से नहीं होगा. The cross-examination should clearly indicate the line of the defense of the prosecution witness, and then you can give your defense witness. If there is no cross-examination on this line, then under such circumstances there cannot be any. Anyway, that is sufficient. When did she depose that the marriage has taken place? This is what.
Your Lordship, it is not on record, Your Lordship.
अरे क्रॉस एग्जामिनेशन में कभी तो आया होगा ना उनका कंप्लेंट.
Your Lordship,
After
the paper
charge-
book that I have received, Your Lordship, it's not mentioned anywhere that the date of the marriage.
State कहाँ है यहाँ? Where is the state? Yes. What do you have to say?
Lordship, the paperwork has been received in my senior's mail, Your Lordship. I have checked that, and my senior is engaged in court number 7.
So what are you? You are a dummy here. We will not record your appearance because you are absolutely you don't have anything. You didn't even pray for a Passover. Didn't even pray for a time.
Passover will be granted. I'll see the LCR, Your Lordship.
No.
For one case, Your Lordship.
You just stand up and then say that you don't have the file.
Your Lordship, I keep
How is it
actually in the
possible?
middle of the proceeding. That's why I didn't interrupt.
सीनियर भी बिजी हैं और जूनियर भी बिजी हैं तो 2-4 जूनियर और रख लीजिए चलिए नेक्स्ट एक केस के बाद 12-15 अभी पास ओवर कुछ मैटर्स है वो करते हैं है ना कॉल करें 12 बजे फिक्स है उसको कॉल करें
This case and the meeting for hearing item 16, Criminal Division 907 of 2015 along with item 17.
Your Ladyship, I informed Mr. Amresh Kumar yesterday. On last date, it was adjourned on grounds that Mr. Amresh Kumar has had an accident and is unable to come to the court. Your Ladyship had granted time for him to appear online, but perhaps because both his hands are not working and there is difficulty in him wearing coat and everything. Therefore, he was praying that let it be listed after the holidays and be able to assist this.
You tell me the date
Last date of order.
आप अपना डेट बताइए कौन सा
Let it be after any day after holidays.
14 sure
Sure.
criminal division number 907 of 2015 with criminal division number 737 of 2015 counsel for the petitioner Mr.
Amresh Kumar.
आप नाम बताइए
Pratyush Shanikya.
प्रत्युष
Shanikya.
submits that the advocate on record for advising the case Mr. Amresh Kumar has met with an accident and is bedridden. Correct? कोर्ट में नहीं घूम रहे हैं ना?
Not day. दोनों हाथ टूटा हुआ है लड़की.
कैसे ऐसे accident?
He fell from the stairs.
तो ये इतना जल्दी तो नहीं रिकवर कर
It's been around 2 weeks. He said it will take around a month, so most probably after 2 weeks he will be there.
इतना जल्दी नहीं हो पाएगा तो थोड़ा और बाद में रखिए At his request, let this matter be posted on 28th of October. ये final disposal में है under the heading for final disposal. The case was admitted only on the point of sentence. State counsel for the state is present.
Passover case, item 3, Criminal Division 260 of 2016 along with item 4.
Which record should I take up first?
My Lord, 260 of 2016.
Yes. Yes, formulate your point in matter.
तो चार चीज केवल पहले बोल देते सर पॉइंट करते हैं My Lord, FIR in this case has been registered under section 120B, 467, 468, 440 against altogether 8 accused persons. Out of 8 accused persons, two have not been charge sheeted. That is Ganda Ansari and Sundar Ansari. Against them, the allegation was that they have purchased motorcycle.
Gandhar Ansari.
Ganda Ansari and
Gandhar.
Ganda, Ganda.
Gandha Ansari and
Sundar Ansari, Sundar.
they were the purchasers.
Yes, it has been.
There was no recovery from them.
My lord, the motorcycle which has alleged to be purchased by them has been recovered from the possession of these two persons. Now thereafter, my lord, after investigation, the charge sheet has been submitted against the six accused persons, including these three petitioners in criminal division number 260 of 2016 under section 467, 468, 471, 473, 414, 255, 263 and 120B of the Indian Penal.
Just a moment. 473, 440, then
55,
255,
263A,
263 capital A
capital A,
and
100 with the aid of 120B. But the cognizance of the offences has been taken.
कॉग्निजेंस में क्या मतलब है आप हमको
हमने उस पे टोटल पे नहीं लिए हैं, इसलिए
नहीं लिए हैं चार्ज किसमें
हाँ
frame
चार्ज
हुआ?
उसी पे सेम हुआ है जिस पे कॉग्निजेंस हुआ है।
बताइए
467,
467,
468,
468,
472, 414,
472, 440,
120B of the Indian Penal.
120B IPC
मतलब
चार्ज फ्रेम
चार्ज फ्रेम डेट हम नहीं बता
कोई
रहे।
जरूरत नहीं है बताइए
मतलब in this case altogether 9 with prosecution witnesses have been examined.
yes
Out of them 1 to 5, PW 1 to 5, they are the witnesses to the seizure list. And rest are 6 to 9 are the member of the raiding party. 9 is the informant. He was not the, my lord, I stand corrected. 6 to 8 are the member of raiding party.
yes
9 is the informant in this case. Now, my lord, the petitioner, 3 petitioners, my lord, I am representing that are Hanif Ansari, Dinanath and Sarfaraz.
in this 260
260. 3 petitioners are there. They have been convicted.
yes
They have been convicted for the offence committed under section 467, 468, 472, 120B and 414 of the Indian Penal.
for the same for all the
हाँ नहीं इसमें एक है शकील अहमद को 414 का कन्विक्शन नहीं था जिसका हुजूर लास्ट
शकील
डे
अहमद तो
हाँ
हो
उसको
गया।
लास्ट डे
छोड़
आपको
दीजिए ना,
सेंटेंस
उससे-
पे उसका
उससे क्या मतलब
तो जजमेंट में कुछ जो हुजूर लिखाएंगे उसमें आ जाना चाहिए इसीलिए क्यों गड़बड़ नहीं कुछ होना चाहिए
कोई
जजमेंट
गड़बड़ नहीं है। हम आप ही का केस देख रहे हैं वैसे सिस्टम को मतलब
जी on appeal my lord the conviction has been upheld sentence has also been upheld now my lord my points are first point that PW 1 to 5 although they have admitted their signature in the seizure list
yes
but they have not supported the factum of the case that any recovery was there in their presence.
not supported the recovery
Not supported the recovery. Only it has been it has been stated during their evidence that on plain paper, when they were somebody told that stated that they signed on plain paper when he was returning from the bank of the river, or he was on the
That's
way.
fine. Okay.
But they have not supported the prosecution
What
case.
else?
No.
All the five.
All the five. So, and rest are the police personnel. Now, in this case, the informant. No, I stand corrected. IO of this case, who has investigated the case,
PW?
नहीं examine.
Not examined.
केवल फॉर्मल है ये. फॉर्मल आईओ है. PW8. He has been examined and he has submitted that I have only filed charge sheet. So the case of the petitioners on account of non-examination of the main IO has prejudiced.
And that
on the
IO has
point.
been examined as?
PW8. Umesh Kumar, Dinesh Kumar.
Yes.
So case of the petitioners are prejudiced on account of non-examination of male IO on the point that place of occurrence recovery since could not be proved.
Place of recovery could not be.
Place of occurrence, recovery, since the witnesses were PW 1 to 5, they have not supported the prosecution case with regard to alleged recovery from the house of the. Now, my lord, I would like to invite your lordship attention towards internal page number 2 of the judgment. My lord, 3 motorcycles have been
Which judgment?
Original court. Page,
Right.
perhaps page 40 is there.
Page 40.
Yes.
Para number?
पारा तो नहीं लिखा हुआ है, लेकिन ये
क्या
मिडिल
लिखा?
पोर्शन में हुजूर हनीफ अंसारी का नाम आ रहा है. मिडिल पोर्शन में जो 98355 है ना नाम
हाँ.
नंबर, उसके नीचे वाले पैरा में
The C-
थर्ड लाइन में हनी हाउस ऑफ द हनीफ अंसारी.
That's right.
Three motorcycles have been allegedly stolen from recovered from the house of the Hanif Ansari. Thereafter, my lord may turn next page. Hanif is the petitioner number 1. Now, my lord may turn to next page 41. Almost same place है इस पेज में भी. Later on, the police party went to the house. My lord is found. ये दीनानाथ प्रजापति का है. Second line में
PW, this petitioner 2.
हाँ, petition number 2. 2 motorcycles have been shown
Okay.
to be recovered from the house of this petitioner.
That's
But my lord, the next line, जो third है Roman 3, with original document kept in box relating to above vehicles. Now, my lord, उसके ऊपर आ जाइए, उसी पेज में ये है एक्यूज नंबर 3, ये पिटिशनर नंबर 3 सरफराज अहमद, जो रिकवरी दिखाया है 3. शुरू से चौथा लाइन 1 इसमें है, इसमें भी है जो रोमन 3 है. उसमें 2 laminated registration book kept in a box related to vehicle number JH02K 5376 and JH12D 6895. Now, my lord, the prosecution could not be able to prove from any causant material that these motorcycles were actually the stolen property, or the petitioners before your lordship have manufactured, counterfeit any document.
Yes.
Since non-examination of the DTO and the main IO of this case, DTO could not be examined in this case by the prosecution. Despite of the same matter, without discussion all these things, both the impugned order judgments have been passed against altogether 6 accused persons and they have been found guilty. My lord, the sections in which the petitioners have been convicted, that are 467, 468, 472, 414 of the Indian Code. Now, my lord, I would like to place the definition of 467.
What do you want to say? We have read the definition many times. What is your point?
Our point is, my lord, that 467 deals with the forgery of document. Prosecution has to prove that petitioners have forged the document.
Then?
But so far these petitioners are concerned, my lord, prosecution could not be able to prove beyond the shadow of doubt that they have indulged themselves in preparing any false document related to the document of the said motorcycles which allegedly been recovered from the house of the petitioners. Stamps, seals, etc., nothing has been recovered from the house of the petitioners. So far, my lord, section 468 is concerned. That deals with the forgery for the purpose of cheating. But there is no any complaint or FIR with regard to the stolen with the motorcycle which has been recovered. And there is no complainant to that effect. So there cannot be any intention to cheat anybody. Since the honor book has been recovered from the house of the Dinanath and Sarfraz.
All the 3 persons.
नहीं, उसका वाला मैं नहीं डिटेल दिया है। पहला वाला जो हम हनीफ का
Registration है ना?
रजिस्ट्रेशन वो है।
Registration.
हाँ जी.
One black
Some-
color here, नहीं उसमें कुछ relating to vehicle number system, registration book. Anyways, बताइए आप.
Now the my lord, so my lord, it can be said that petitioners have never been found in possession of such instrument which can be used as counterfeit. So there is no application of section 467, 468.
In possession of any
My lord.
forged document.
Any forged document or any counterfeit, preparation of counterfeit. Seal, counterfeit seal. Now motorcycles, my lord, they are the material witness in this case. Material exhibits must be. But the motorcycle have never been exhibited in this case. I'm sorry, my lord. I'm sorry. इसको नहीं. हम एक बार इसको
Not produced before the trial.
हाँ तो वही तो बोल रहा हूँ. तो एग्जिबिट कैसे होगा? एग्जिबिट होना चाहिए. एग्जिबिट होगा तो फिर आपको मिलेगा. एग्जिबिट नहीं होगा. एक बार हम वेरीफाई भी कर लेते हैं. एक मिनट. Signature.
If the document has not been produced before the trial court lordship, therefore it seems that the motorcycle is not so far.
आपकी बात समझ नहीं आई हमको.
नहीं हुआ है. ये पेज 5 देखा जाए. पैरा 11.
हम लिख लिए आपकी बात. हम तो रिकॉर्ड चेक करके ही ऑर्डर
हाँ
करेंगे.
नहीं हो तो इसीलिए हम बीच बीच में प्लेस कर देते हैं. मोटरसाइकिल आया नहीं है. जजमेंट में ही है. सिग्नेचर है. सीजर लिस्ट हुआ.
अब हो गया ना. और क्या पॉइंट है ये बताइए.
अभी तो चलेगा.
अब आप सीधे मुद्दा पे आइए कि परवर्सिटी क्या. These are the
Perversity
points
तो-
we have noted.
हाँ.
These points according to you have not been considered.
Not been considered so far section 414 is concerned. 414 deals with the for assisting the retaining the stolen property with a person.
Yes.
But since the paper document with of the concerned motorcycle have been found in possession of the petitioner, so it could not be said that there is any application of section 414 of the. Now, my lord, the page 5 will reveal the informant was
आप
posted.
जरा आराम से तेजी से बोलिए. ठीक है. इतना लेजरली इतना आराम से बोलने का जरूरत नहीं है. You can pick up your speed. Right?
जी जी आप तो
ये
हुजूर की नोट
इस
करती
तरह से
हैं तो
करिएगा तो 3 दिन तक आपका कहानी नहीं खत्म.
हुजूर की
रिवीजन है.
नोट
आप बस I'll hear you for 10 minutes more. इससे ज्यादा रिवीजन में स्कोप नहीं है सुनने का. आप एकदम परवर्सिटी दिखाइए. If you satisfy the court on perversity, you take the order.
Yes. Now, my lord may kindly have a look to page 5 of the impugned judgment of lower court, which would go to suggest that the informant was posted at Lohardaga police station.
Page 5 of the trial court judgment.
Trial court. Last paragraph, para 12
Yes.
हम place कर रहे हैं.
Yes.
Second line from the bottom. उसमें लिखा हुआ है कि he was posted at लोहरदगा PS since 15/1/2009.
This is PW?
PW 4, 6, Madan Prasad.
He is the informant.
He is not the informant. PW 9 is the informant. Umesh Kumar.
So what do you want to say?
I want to say, my lord, that he was not authorized by the law to raid the house of Dinanath and Sarfaraj, since they are residing beyond his jurisdiction.
So PW6
PW6 has stated
was not authorized
Umesh Kumar Thakur
to be a part of the team.
to be the part of the team.
Yes, what else?
Now, informant is also officer in charge of the same police station, that is Lohardaga police station. PW 9, Umesh Kumar Thakur.
PW9.
Umesh Kumar Thakur.
So he was also not caught.
Not competent. Since house of the petitioner Dinanath and Sarfraz, situated in different police station.
And what about one?
One Hanif Ansari was he was within the Lohardaga police station.
What else?
Now, my lord, on this point, I am relying upon the judgment of the Supreme Court in the case of Roy Bedi versus State of Kerala.
Citation.
Citation is, my lord, 2000, volume 8, SCC 590.
590. Para number. You have given the list of books. तो आप ही पढ़ी. पैरा नंबर बताइए.
I'm just listening. My lord, the para 18. Although, my lord, this case is of the NDPS, but law has been enumerated with regard to the raid by incompetent authority or who is not the authorized authority.
What else?
Where criminal proceedings are initiated based on illicit material collected on search and arrest, which are per se illegal and vitiate not only a conviction and sentence based on such material, but also the trial itself, the proceeding cannot be allowed to go on, as it cannot but amount to abuse of process of the court. In such a case, ये हम आपको एक बना के भी तुरंत दे देते हैं. कितने क्या क्या पैराग्राफ है सब काम लिखते हैं.
नहीं आपके पैरा 18 लिखा है ना.
12.
आप अपना
18
18 है ना आपका पैराग्राफ. नोट कर लिया. तो बना के देने की कोई जरूरत नहीं है. आगे बताइए.
So, my lord, in my humble submission, the conviction under section 467, 468 and 471 that are bad in law, primarily, my lord, because of 414 में हम बाद में आएंगे, because there is the prosecution could not be able to prove that these petitioners are indulged themselves.
That please don't repeat. I have already noted it.
No, my lord, I'm concluding. So, my lord, I am recapitulate all
No,
these
no,
things.
I've noted everything, every word I have noted.
Yes, ma'am.
There is no need to recapitulate. It's a very short argument. Yes, आगे बताइए क्या.
Now, my lord, this section 414 के लिए, I am relying on the judgment of Patna High Court, Khodadin Ansari, reported in 2011 for Eastern India criminal cases 476 within bracket PAT.
476.
G.
Para number?
Para 710.
7M.
G.
What does it say? You can summarize it. You don't need to read the entire paragraph.
Para
Just
7.
tell us what is it.
My lord, 7 may be like, my lord, 9 and 10, it may be 9 and 10.
कितना paragraph?
9 एक छोटा सा जजमेंट है 13 पैराग्राफ का
7 to end.
नहीं 9 and 10 को 7 4 13 को डील कर रहा है इसलिए उसको छोड़ दिया
9 and 10. What
10
is the ratio?
ratio, my lord, as may appear from the above definition, the act of assisting in concealing or disposing of or making away with property has, firstly, to be voluntary, and then with knowledge or under reason to believe that the property was a stolen property. The word voluntarily has been defined by section 39 IPC. A consideration of that particular definition may indicate that the act of concealing a property which is known to be a stolen property must be with an intent and purpose of concealing. However, that intent must be blended with the knowledge that the property was stolen. Besides the knowledge which could be derived from the word voluntarily, the section further reads that while voluntarily assisting in concealing or disposing or making away any property, the offender must have the knowledge that it was a stolen property or must have reason to believe that it was a stolen property. The first requirement of constituting the offence under section 414 IPC is that the offender must know or has reasonable ground to believe that the
That's
property.
what you have got. These
that
are the
he should-
basic ingredients, and you say that since he had all the documents, that
Documents and,
therefore there was
and
no reason
prosecution. Next-
for him to believe,
One-
and there was no intent to conceal.
Yes, next leg of argument in this particular section, that if prosecution could not be able to prove that the petitioner has got any knowledge.
I have understood your point.
Yes, ma'am.
What else?
Same thing has come along. Of course, it is also from the Patna High Court.
Don't repeat a judgment. दोनों
नहीं,
में से
नहीं,
एक ही बात है ना. एक ही पॉइंट पे 4 जजमेंट का कोई काम नहीं है, एक जजमेंट सफिशिएंट. राइट?
इसमें 100
दोनों में से चूज कर दीजिए.
114 ए के ऐड से इसको किए हैं, इसलिए इसको प्लेस कर दें. अगर बोलिएगा तो करेंगे.
नहीं छोड़ने. हम आपको क्यों बोलेंगे? नहीं, हम आपको क्यों बोलेंगे छोड़ दीजिए. You say that it is on the same point.
हाँ, सेम वही है. 414 का जो डेफिनेशन है, केवल ये एक नोट कर लिया जाता है.
बताइए.
2010 1 EICC 218 within bracket PAT.
218.
जी.
पटना. पैरा नंबर?
इसका पैरा नंबर है 9 to 14.
Any other point?
I think I can.
What about the
और केवल एक चीज वो DTO वाला जो था, चूंकि रिकवर हुआ था, वो अगर जो पॉइंट लिख लिए तो ठीक है.
क्या
Note
DTO
down
वाला?
DTO could not be examined in this case.
You have said so. I have
Yes.
recorded it.
Yes, ma'am.
आपका एक शब्दशः रिकॉर्ड किया.
हाँ,
देखिए
नहीं,
already
हम
है.
इसीलिए तो धीरे कर रहे थे. 1 मिनट केवल आप दे दिया जाए.
और एक बताइए क्या पॉइंट.
So, my lord, so far section 120B is concerned, prosecution could not be able to prove there is any meeting of mind.
That's all. देखिए जरा इनका सबमिशन. This is in connection with criminal revision number 260 of 2016.
Yes, 260 or 60.
The learned counsel for the petitioner, while assailing the impugned judgments, has submitted that although concurrent findings have been recorded by the courts, but
For a moment, 1 minute. no independent witnesses have supported the case of the prosecution.
ये तो आपको बता ही दिए हैं.
वो एक लाइन है.
अब एक बार भी एक शब्द मत.
No, हम बैठ रहे हैं.
आप बैठ जाइए.
हम बैठ रहे हैं.
The learned counsel for the petitioner, while assailing the impugn judgments, has submitted that though there are concurring findings recorded by the learned court, but the findings are perverse, and therefore they call for interference by this court. He has submitted that altogether 8 accused persons, FIR was registered against altogether 8 accused persons, but 2 persons were not charge sheeted, namely Ganga Ansari and Sundar Ansari, who were alleged to be the purchasers of the stolen motorcycle, on the ground that there was no recovery from them. He has further submitted that ultimately the charge was framed for offence under section 467, 468, 472, 414, 120 capital B of Indian Penal Code against 6 accused persons, including the 3 accused persons involved in this case. Altogether 9 prosecution witnesses were examined. PW 1 to 5 were the Caesar witness. 6 to 8 are the members of the raiding party. 9 is the informant of the case. He has submitted that PW 1 to 5 have admitted their signature on the Caesar list, but they have not supported the recovery inasmuch as they had stated that they had signed on plain paper. The learned counsel submits that the investigating officer who had investigated the case has not been examined, and therefore the petitioners have been prejudiced on account of non-examination of the concerned investigating officer. The IO who has been examined as PW8 has stated that his only role was submission of the charge sheet. The learned counsel submits that on account of non-examination of the concerned investigating officer, the place of the occurrence and also the place of recovery could not be proved. While further arguing, he has stated that there is no independent witness in the entire case. With respect to offence under section 467, 468 and 472 of Indian Penal Code, the learned counsel has submitted that the prosecution has not proved that the petitioners had forged any document. He has further submitted that no counterfeit stamp, seal, etc. have been recovered from the possession of the petitioners. Rather, it is apparent from the discussions made in the trial court judgment that the recovery of the alleged recovery of motorcycle was accompanied with certain original documents in connection with the vehicles involved in the case. He has submitted that there is no evidence that it was the petitioners who had forged the documents. He has also submitted that there is no evidence that forgery was committed for the purposes of cheating. The petitioner were never found in possession of any forged document or involved in preparation of any counterfeit seal. He submits that the district transport officer was not examined in the case, which has also prejudiced the case of the petitioner. he has further submitted that the motorcycles that the recovered, so-called recovered motorcycles, which were material exhibits, which were never exhibited before the court. He submits that neither the seizure has been properly proved nor the motorcycles have been exhibited. The learned counsel has further submitted that the offence under section, the learned counsel has further submitted that PW6 was posted at Lohardaga since 15/1/2009 in police station Lohardaga since 15/1/2009, and in the informant PW9 is the officer in charge of Lohardaga police station. The two petitioners, Dinanath and Sarfaraz, their house is located under different police station, and therefore they had no jurisdiction to raid the house of the petitioner number 2 and 3. And accordingly, the entire seizure is vitiated. He has relied upon the judgment passed by the Honorable Supreme Court, reported in bracket 2008, bracket close 8 SSC 590, para 18, to submit that although the said case was under NDPS, but it has been held that raid by incompetent or unauthorized person is per se illegal, and no conviction can be based on such raid. The learned counsel has further submitted that no case under section 414 of the Indian Penal Code was also made out, in view of the fact that the petitioners were found in possession of the documents of motorcycle, which was alleged to be recovered from their possession. He has further submitted that the basic ingredients of section 414 of IPC has not been made out, in view of the fact that there is no material to show any knowledge or any knowledge on the part of the petitioner that the motorcycle was stolen property, and there was no reason to believe on the part of the petitioner that the motorcycle was stolen property. He has also submitted that the intent and the purpose of concealing or voluntarily concealing the property has also not been proved. He has relied upon the judgment passed by the Honorable Patna High Court, reported in bracket 2011, bracket close 4, Eastern India Criminal Cases 476 within bracket Patna, para 9 and 10. He has also relied upon, on the same point, he has also relied upon the judgment reported in 2010 within bracket 1, bracket close, Eastern India Criminal Cases 218 within bracket Patna, para 9 to 14. He has further submitted that the prosecution could not prove the meeting of mind, and therefore the conviction under section 120 capital B is also not made out. The learned counsel submits that these aspects of the matter have not been properly considered by the court concerned, by both the courts, and accordingly the impugned orders are fit to, impugned judgments are fit to be set aside, and the petitioners be acquitted. दूसरा केस का बताइए.
With the help of 120B कर दिया जाए उसको.
क्या चीज़?
With the help of 120B
Meeting of mind ना?
हाँ, वो 120B का अपना independent identity नहीं है, इसीलिए with the help of
120p में इंडिपेंडेंट कंडीशन नहीं
मैंने
होता है.
नहीं, वो किसी के साथ ऐड होकर के होता है, किसी पर्टिकुलर
सिर्फ 120p में किसी का कंडीशन हो सकता है.
वो जब भी होगा 302 के साथ लग जाएगा, 304 एक के साथ लग जाएगा, ऐसे प्लेस कर दें 120 भी बोलेंगे तो।
He has submitted that the petitioners could not have been convicted with the aid of 120 capital B of Indian Penal Code. बताइए नेक्स्ट केस में क्या?
My case
ये
is
जो बहस की है इसके अलावा क्या?
हाँ इसी के अलावा my case is similar to Dinanath.
दीनानाथ
There is two motorcycle recovered before the lots of conditions. There's page 2 of the internal trial court judgment.
yes
The last paragraph. Then later on, informant read the house of Irfan Ansari in possession of two independent witnesses, where on two motorcycle and owner book have been recovered from his house, which details are given. And laminated owner, two motorcycle along with two laminated owner book of the
that's
Lots of in this case, the seized motorcycle has not produced before the.
जो वो बोले हैं उसके अलावा क्या बोलना है ये बताइए.
उसमें एक जजमेंट हम देना चाहते हैं for non production of the report seized article possession before the appellant or accused person appellant extended to benefit of doubt and acquitted.
Citation बताइए.
नहीं ये
Citation बताइए. अच्छा दे दीजिए.
I refer para 12, 15 and 14 though this case was NDPS lordship, but the para 12 and second lordship I have so far as section 467 is concerned lordship.
Yes 467.
I have submitted one judgment to Supreme Court Lordship. Muhammad Ibrahim.
Citation बताइए.
Citation Lordship. 2009, Volume 4, East India Criminal Cases.
Just
Lordship judgment is there.
did this is 796.
2009.
This is 796 now.
Yes, yes.
796 of
2016.
इसका है पैरा नंबर है 12 and 14 और इसका बताइए
8 and 9.
पैरा 18. क्या बोलना चाहते हैं इसमें?
इसमें के 467 इंग्रेडिएंट्स या फुलफिल नहीं अगर मेकिंग ये नहीं हो रहा है
ठीक है. और कुछ बोलना है?
and so far as judgment is concerned, Lordship, the learned trial court as well as the appellate court has not discussed the evidence under section 467, 468 and 472, Lordship. In this, kindly see, Lordship. Therefore, the order passed by the trial court as well as the appellate court is perverse, Lordship. And without discussing the evidences of under section 467 and 468 and 472, Lordship, they have convicted in this section.
The learned counsel for the petitioner in criminal revision number 796 of 2016 has adopted the arguments advanced on behalf of the petitioners in criminal revision number 260 of 2016 and has made further submissions and has made additional submissions. He has submitted that the case of the petitioner is in the same footing as that of Dinanath.
Dinanath.
उनका भी jurisdiction का issue
नहीं
है?
jurisdiction होगा
तो फिर क्या है?
So far recovery part is concerned.
So far as the recovery part is concerned. However, so far as the jurisdiction of the raiding party is concerned, the same would not apply to the case of the
Yes.
petitioner. He has further submitted that the learned courts have not discussed the evidence in connection with offence under section 467, 468 and 472 of IPC in order to convict the petitioners, and therefore the ensuing judgments are perverse. The learned counsel has further relied upon the judgment passed by the Honorable Supreme Court in the case of Ashok alias Dangar Jaswal versus State of MP, reported in 2011 within bracket 5, 2011 within bracket 5 SCC 123, and has referred to paragraph number 12 and 14 of the said judgment. He has, by submitting that on account of non-production of material exhibits and without any explanation for non-production of such material exhibits, the conviction cannot be sustained and the accused are entitled for benefit of doubt. He has further relied upon the judgment passed by the Honorable Supreme Court reported in 2009 within bracket 4 bracket close Eastern Criminal Cases 6 SC Mohammed Ibrahim versus State of Bihar para 8 and 9 to submit that the basic ingredients for offence under section 467 and 471
Oh, yes, sir.
471 of IPC
So
has been-
471 is the precedent of under section 467.
have been duly discussed and the basic ingredients for convicting the petitioner in the present case has not been made up. हो गया? आपको क्या बोलना है? Both of you? Yes, madam.
PW 9 Umesh Kumar Thakur, he said that one of the 3 motorcycle and papers from the house of the Dinana Prajapati has been recovered. And petitioner
He had said many things, but material exhibits have not been produced, right?
and the papers of the vehicle is registration paper of the vehicle is
The documents which were seized have been exhibited.
papers of the registration of the vehicle has been exhibited, and that has not been named in the name of the petitioners.
It was not in the name of the
Name of
petitioner.
the that is come in para 13 of the appellate court judgment.
The learned counsel appearing on behalf of the state, M.S. Mahua Palit, while opposing the prayer, has submitted that the documents relating to registration of the seized motorcycle was duly exhibited, and it has come in paragraph 13 of the appellate court judgment that the vehicle was not even standing in the name of the petitioners. What else? Though it was recovered from their possession. और कुछ बोलना
And
है?
motorcycles were marked as M1 to M12, my lord.
Material exhibit.
M1 and M12, yes, my motorcycles were marked as M1 and
M1 and
M12. M1 to M12 motorcycles.
the learned counsel has submitted
Page
that
5 of the
the
trial court judgment.
page number
Page 5, list of the exhibits.
has submitted that has referred to page 5 of the trial court judgment
After exhibit 7, my lord.
to
Exhibit 7 के बाद
to submit that
M1 and M2, M12 motorcycles.
to submit that the seized motorcycles were duly exhibited before the learned court as material exhibit which were marked as M1 to M12. And therefore, the argument of the learned counsel for the petitioners that the seized motorcycles were not exhibited is incorrect and contrary to the records. Anything else? That's all. आपको क्या बोलना है?
The two motorcycles have been recovered from the house of this petitioner lordship, and the owner is in the name of the other person, not in the name of this petitioner lordship. And the registration number of the motorcycle, registration number 323972 has been executed as exhibit 3 lordship, as per the update court judgment, page number 9.
Yes. Same argument? हाँ? The learned counsel, दोनों counsel का एक ही साथ आना चाहिए. They have submitted. Right? चलिए. मुझे बात करें. Arguments का concluded, judgment is reserved. ये दोनों लगाइए इसके साथ. इसमें जो ट्रायल कोर्ट जजमेंट में जो सीजर दिख रहा है ना, वो उसको जजमेंट में डाल देंगे, ऑर्डर एडजर्नमेंट ऑर्डर में डाल देंगे, है ना, इससे जजमेंट लिखने में सुविधा होगी.
Item 5, Passport case, criminal division 1430 of 2016.
उसको कल वो कल रात में उसी को पढ़ते रहने पड़ा था, ये पूरी तरह से तैयार नहीं.
कौन सेक्शन का केस है? 414.
414 का ही है.
Learned counsel for the petitioner, Mr. Rajesh Kumar, submits that he has already argued 2 matters before this court today, and he could not read the brief yesterday. He submits that the matter be posted tomorrow. Counsel for the state is present.
एक बार LCR दीजिए.
Final disposal में.
एक बार LCR दीजिए.
Passport case item 8, criminal division 1397 of 2017.
This case, Ladyship has ordered that I will deposit the special messenger cost. It was listed on 12/9/2024. That day also the order was not uploaded.
I know.
Thereafter,
Just a moment. Subsequently, when this case was, we came to know about it, that this was not listed.
And
on that day, we extended the time.
because the file was not available, I have sent thrice.
क्या चीज़ के लिए?
वो सेक्शन में मुझे फाइल जब तक नहीं है, वो डिपॉजिट ही नहीं ले रहा था कि किसमें हम लेंगे.
नहीं, just a moment. You just see.
I have even asked the court master.
Please hold on.
Yes, my lord. Sorry.
This is 4th of September 2024, right?
And
we have also. You have seen this order?
Yes, my lord. I've seen that order. It was that order was not even uploaded on 12/9. It was listed on 12/9, my lord. Again, but not taken up. Then I specifically asked the court master that it has not been uploaded, my lord.
Okay,
And
just a moment. We listed it on 12/9, but on 12/9 perhaps it was not taken up.
it was not taken up. Yes, my lord. And that day also the order was not uploaded, my lord.
We have also directed to call for the entire order sheet of the appellate court.
And I have to deposit the special messenger cost. That deposit, my lord, they were not taking.
Yes, I am aware of this. I'm aware of this, but when on 12th, I had just asked them to post it on 12th because there was an order to that effect. But on 12th, it could not be taken.
It could not be taken up. And 12th also it was not
deposit it
uploaded,
now?
my lord. Now I will deposit, my lord. The moment, my lord. Today only I will deposit.
12th, it was not taken up. There was no question of any uploading.
No, the earlier order, my lord, first order, on which I have been directed to give the
No, it
special.
was uploaded on 11th.
My lord, 12th we have checked, my lord, because specific.
No. We have our own record. Every uploading is recorded in the
And
order
then
sheet.
I may be wrong, my lord. Then because 12th, I have sent my court thrice, my lord. It's not my intention to.
No. I'm aware of this order because somehow it was
Yes,
not
my lord.
placed
Yes, my lord.
for correction. So at times it happens.
My lord, my lord, today itself I will deposit.
You deposit.
I will deposit, my lord, today itself.
अब इस ऑर्डर के अपलोडिंग का चक्कर नहीं होना चाहिए.
ये आप हुजूर
है ना,
इनको
ये ऑर्डर जो है आप वहाँ कम्युनिकेट कर दीजिए.
कम्युनिकेट कर दीजिए, बस.
Criminal Revision number 1397 of 2017. Counsel for the petitioner is permitted to deposit the cost in terms of order dated 4th of September 2024 by tomorrow.
But
Right.
one thing I want to point out, my lord, if your ladyship allows, my lord, there was similar case of the present petitioner wherein it was dismissed for default, my lord. Similar on the ground the defects has not been removed. There, my lord, this honourable court has allowed the criminal revision. Similar ground, my lord. A coordinate bench of this honourable court.
हम लोग को तो अभी आप जो सबमिशन
हाँ वो बस हम सिर्फ इतना पॉइंट आउट
बस इतना ही पॉइंट है कि आपको सरेंडर करना है कि इसी बेल बॉन्ड में चलना है, इसके बियॉन्ड कुछ नहीं।
हाँ सरेंडर क्योंकि हम अपियर किए हैं इफ माय
यही तो हमको देखना है ना
क्योंकि हम अपियर किए हैं अगर मेरा बेल बॉन्ड नहीं
यही
रहता
हमको
तो
देखना है
हाँ ठीक
यही हमको देखना
ठीक
है
है I've got the point.
You remember?
Yes,
there was
ma'am.
so much of argument on this.
Yeah,
point.
well, whether that provisional
And
bill was
that-
confirmed or not.
And further, your pleadings were also considered. What were your pleadings? And whatever you have stated,
Yeah, ma'am.
revision में क्या ही pleadings देखना
हाँ,
है? We are bound by the records only. But we have to get it confirmed.
As
You also said that you will also seek instructions.
I've sought instruction, my
Your
lord, that they are, my
provisional
client
bill
is
was
saying that
confirmed?
it was confirmed, my lord, and they have appeared also on the one date, and that is recorded in the order itself, my lord. If I would have not been taken provisional bill, I would have taken into custody immediately when I have appeared, my lord.
उसमें लिखिएगा एक चीज़ और the learned counsel for the petitioner on instruction from his client has submitted that the provisional bail granted to the petitioner was confirmed by the appellate. ठीक है इसको रिकॉर्ड मंगाइए उसको ध्यान देखिए पोस्ट दिस केस ऑन 15th of October let this order be नहीं इसका तो फैक्ट्स क्या होगा आप जमा करिए आज
हम जमा कर देंगे
Also case item 9, criminal division 1722 of 2017.
17th if it can be placed, my lord. 15th, I have some difficulty if it is on
17th.
17th. Deeply obliged.
Yes, petitioner. Yes, what do you have to argue?
Your Lordship, the complaint has been filed in the year 2006, Your Lordship. Till that, the second marriage was not solemnized. It was stated in the complaint that because he wanted to solemnize the second marriage, he has ousted me from the house, the matrimonial house, Your Lordship. Later on, the charge was framed in the year 2014, and it was framed only under section 498A. Your Lordship, it was not charge was not framed under 494 because it was the subsequent event.
That's right.
In the deposition which was there.
So therefore,
Yes.
so therefore, how can his conviction be sustained on the ground that the petitioner had remarried?
Your Lordship, in this case, 498A is only for the ill treatment during the pregnancy when the informant was pregnant. After the born of the child, Your Lordship, she was ousted.
That is not
from
the reason for conviction by both the courts.
Yes, Your Lordship, that is not there. But
That is therefore we are in revision jurisdiction. Both the courts have convicted him on the ground that he has remarried, and there is no finding that merely because a pregnant lady is thrown out of her matrimonial house, that much is sufficient for her to commit suicide. Yes, and there is no other. The assault has not been proved at all. There is no assault.
Your Lordship,
Only
DW
mental cruelty.
DW1, Your Lordship, he has stated in paras. DW1, who is Sukhdev Soren, he has stated in para 7 that their fight used to take place between both the parties, Your Lordship.
So,
as related to the assault, only PW2 has
are
stated.
you aware
that-
of the ingredients of 498?
Yes, Your Lordship.
You tell us. What is the ingredient of explanation A? And what is the difference between explanation A and explanation B? 498. Yes, tell us.
Yes, Your Lordship. Your Lordship, explanation A says that any willful conduct which is of such a nature as is likely to drive a woman to commit suicide or to cause grave injury and danger to life. Although injury is not there, only Your Lordship, fight used to take place. Only PW2
Is
has
there any
stated that-
finding Is there any finding by the courts that because she was thrown out of the matrimonial house and on the basis of evidence, that was enough for her to go and commit suicide? That's it. It's a case for acquittal. You cannot be convicted for a subsequent incident.
Conviction is only based on your Lordship 494. That is not there.
On the date when the complaint case was filed, that incident had not happened.
Yes, Your Lordship, that has not happened. Only there was a injury.
Criminal Revision 1722 of 2017. Heard the learned amicus appearing on behalf of the petitioner, or there are two amicus.
Yes, ma'am.
You are also amicus?
Yes.
On behalf of the petitioner and opposite party number 2. The learned counsel for the state MS, your name?
Sharda Kumari, Your Lordship.
Sharda Kumari is also present.
Your Lordship, AC to Mr. Pankaj Kumar may kindly report.
Assistant, Mr. Pankaj Kumar, I want to know from you. Mr. Pankaj Kumar का नाम देंगे, उनके साथ उनका शारदा कुमार. At the time of filing the complaint petition, second marriage had not taken place. The conviction is on the ground that second marriage has been performed and therefore there was torture. Can it be sustained?
But during evidence.
During evidence, it has come
that she has performed.
that the husband has performed second marriage. Can it be sustained? No charge was also framed under section 490.
Must be charged.
नहीं है, charge नहीं है.
So,
नहीं चलेगा ना? और 494 में कोई assault और इसका कोई evidence नहीं आया.
उसमें नहीं चलेगा. चार्ज ही नहीं है 494 में.
और डिमांड है नहीं, इसीलिए एक्सप्लेनेशन बी में नहीं आता है. राइट? Mr. Pankaj Kumar for the state along with me. Distribution is directed against the judgment dated 12/7/2017, passed by learned Principal Sessions Judge Sahibganj in Criminal Appeal number 5 of 2016, whereby the appeal has been dismissed. The petitioner has been convicted. The petitioner, the husband of the opposite party number 2, has been convicted and sentenced by judgment dated 22/1/2016, passed by learned Judicial Magistrate First Class Sahibganj in connection with PCR case number 177 of 2006 and TR number 1 of 2016 for offence under section 498 capital A of Indian Penal Code, and has been sentenced to undergo simple imprisonment for a period of 1 year and pay a fine of ₹1,000 with default sentence. The learned amicus appearing on behalf of the petitioner has submitted that the judgment passed by both the courts are perverse. He has submitted that the complaint was filed for offence under section 498 and 323 of Indian Penal Code on 26/5/2006, primarily alleging that the complainant was thrown out of her matrimonial house while she was pregnant, and the accused had taken possession of one daughter and deprived the complainant of her marital home. It was alleged that the husband was planning to perform second marriage. The complainant was dropped by her husband in Khijiria village, from where he ran away after leaving her in lurch. The learned counsel submits that the conviction of the learned counsel submits that at the time of filing the complaint, it was only mentioned that the petitioner was planning to perform second marriage. However, in the evidence it has come that second marriage was performed by him later, but the petitioner has been convicted for offence under section 498 capital A of Indian Penal Code on the ground of mental cruelty by holding that performance of second marriage is mental cruelty within the meaning of section 498 capital A of Indian Penal Code. The learned counsel, while referring to the evidence of the complainant as recorded in the trial court judgment itself, has submitted that in paragraph 20 of the cross-examination, the complainant had admitted that जमीन के लालच के कारण ये झूठा केस किए हैं. Though she had initially denied the suggestion made to her that she had filed the case on account of her greed over the land of her husband. He has further referred to the evidence of CW2 to submit that the complainant witness has herself stated that he had no idea about any assault, by stating that inverted comma मारपीट के बारे में हम नहीं जानते हैं. The learned counsel submits that no assault has been proved, and admittedly there was no demand for dowry. Therefore, the case was essentially for offence under section 498 capital A, falling under explanation A. He submits that the conviction on the basis of second marriage which had subsequently taken place cannot be sustained in the eyes of law. The learned counsel appearing, the learned amicus appearing on behalf of the opposite party number 2 has opposed the prayer and has submitted that there are concurrent findings recorded by both the courts, and therefore the same do not call for any interference. However, the submissions made by the learned amicus for the petitioner as recorded above has not been, with regard to the evidence and the materials on record, has not been disputed by the opposite party. The learned counsel for the state, Mr. Pankaj Kumar, has also opposed the prayer. However, during the course of hearing, he has also not disputed that at the time of filing the complaint case, the second marriage was not performed, and it was only later on the second marriage was performed, and the conviction is primarily on account of the performance of second marriage, which has been held to be amounting to mental cruelty. It is also not in dispute from the side of the state that there is no allegation of any demand of any property from the opposite party number 2 by the petitioner. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the prosecution story as per the complaint as recorded by both the courts and also apparent from the complaint is as follows. वो उसी से ले लेंगे है ना. dates here आए हैं ना? देखो. This court finds that there is no allegation of demand of any property from the opposite party number 2, by the petitioner from the opposite party number 2, either as dowry or otherwise. The complaint was filed for offence under section 498 capital A and 323 of IPC against 2 accused persons, the petitioner and his mother. The charge was framed under section 498 capital A of Indian Penal Code on 19/6/2014. At the stage of trial, the complainant examined 2 witnesses. On the other hand, the defense also examined 2 witnesses, and none of the parties exhibited any document. The learned court, after scrutinizing, this court finds that, as per the complaint, the petitioner was planning to perform second marriage. This court finds that the learned trial court convicted the petitioner primarily on the ground of performance of second marriage, and acquitted the co-accused, the mother-in-law of the petitioner, for offence under section 498 capital A.
Mother-in-law of the complainant.
Mother-in-law of the complainant, for offence under section 498 capital A of IPC, as none of the witnesses had spoken about any bodily cruelty or mental torture meted out to the complainant by the co-accused. The appellate court also considered the materials on record and recorded that the factum of solemnization of second marriage was established by evidence on record, and under these circumstances, expulsion of the complainant by the petitioner from his house amounts to cruelty, which would frustrate and would fall within the explanation A of section 498 capital A of IPC. This court finds that both the learned courts have convicted the petitioner by referring to the second marriage performed by the petitioner much after the complaint. The complaint itself indicated that the petitioner was planning to undertake second marriage. This court finds that no charge was framed under section 494 of IPC, and rightly so, as the second marriage was not performed at the time of filing of the complaint case, and there was no such allegation that the second marriage has already been performed. This court is of the considered view that while convicting the petitioner for offence under section 498 capital A, one of the prime consideration which has been taken into consideration is the second marriage performed by the petitioner after filing of the complaint case. This court is of the view that such approach of the learned courts, by taking into account the subsequent event which had taken place after the filing of the complaint and in connection with which there was no allegation in the complaint and no charge was also framed, the conviction of the petitioner for offence under section 498 capital A is perverse and calls for interference for the ends of justice. The conviction is hereby set aside ताकि इनका application का आप लोग अपना बिल बना लेंगे और legal aid से ले लेंगे. It will be included. Corrections होगा order में, right? आप कर सकते हैं, पढ़ सकते हैं, है ना? तो बस अब अपना केस खुद से करिए. अलाउड कर दीजिए, कन्विक्शन सेटिस्फाइड कर दीजिए.
Item 10, Criminal Division 760 of 2020.
Yes, petitioner.
Lady, on earlier occasion, I had given a list of dates. My lady, this criminal division has been filed after a 125 court petition was rejected. I will straight away come to the publicity in the order. That is at internal page 13 of the lower court's order. Right.
13. Okay.
Thirteen, 14 and 15.
Yes.
At from the bottom, I'll be placing the.
You just tell us the point and then we will read it.
The
What is the
point
point?
exactly is that some photographs were annexed in the as exhibits in the lower court records. On the basis of those photographs, those photographs were not taken as evidence, and those photographs clearly implicated that the petitioner and the respondent were living as husband and wife for a long period of time. So at at page 15 of the lower court's record, if I may be allowed to place it.
Yes.
Fifth line from the top.
From the top.
Yes.
Yes.
The photographs were taken has been produced before the court. Hence, the
No,
set
it's not matching. Internal page.
internal page.
Internal page
last
15 or running page 15.
Running page 23.
Running page 23. Okay. Yes. It appears that.
I will just start with the page 14.
Yes. You just read the finding, right? Let us have a look at it. Para 16. You just start reading.
I have heard the submission advanced on behalf of
both sides and scrutinized the evidences available on record. It appears that the petitioner Seema Devi has filed this case for getting maintenance for herself and by claiming that she is legally wedded wife of respondent and their marriage was solemnized in the year 1995 at Asansol. In support of her case, petitioner has examined altogether 7 witnesses, including herself as PW4, and during her evidence, she has supported that her marriage was solemnized with respondent about 20 to 23 years ago at Asansol Court, and after marriage, they lived together at the quarter of respondent as husband and wife. But from last 6 years, respondent is not maintaining her, and she has stated that her husband, respondent, is an employee in Tata Forgery and having sufficient means, whereas she is having no source of income, but her husband refused to maintain her from last 6 years. In support of her plea, she has also filed original medical card Exhibit 1 issued in favor by Tisco Zamadova showing name of her husband as Brinda Prasad, original place slip of the respondent Brinda Prasad, Exhibit 21, photocopy of the passport issued in the name of Brinda Prasad and Seema Devi, Exhibit 3 and 7, photographs of herself and respondent, Exhibit 4 series. But in her cross-examination, petitioner admitted that earlier she was married with Brahmanan Paswan and against him she has also filed TMS 214 of 97 before the Family Court Dhanbad. PW2 to PW4, PW6 and PW7 are alleged to be the neighbors of the petitioner and they have commonly stated that petitioner and respondent are living in company's quarter from 20 to 22 years as husband and wife, but from 5 to 6 Brinda Prasad was not living with the petitioner and not maintaining her. But in their cross-examination, they have stated that they have not seen any paper regarding marriage of the parties. PW1 Rajan Paswan is alleged to be cousin brother-in-law of the respondent and he has stated marriage with petitioner was recognized with respondent in the year 1995 and since then they are living as husband and wife. But in the cross-examination, he has admitted that Seema Devi get divorced from her husband, but he could not file any proof in this regard. He has also not been able to state a date of marriage of the petitioner respondent. PW5 Kamlesh Paswan is alleged to be maternal nephew of the respondent. And he stated they know the petitioners and I both used to come in house for matrimonial ceremonies, but they are living as husband and wife. But in his cross, these all are not so relevant. Stated the marriage of petitioner is one. He has stated that he has come to depose in this case at the instant of petitioner. On the other hand, respondent in his show cause as well as in his evidence has categorically stated that petitioner is not his wife and he has specifically stated that he has neither solemnized marriage with petitioner nor living with her at any point of time as husband and wife. He had never established physical relation with her. Respondent has also said that he is working in Tata Forgery and a quarter was allotted to him by company and on the request of the neighbors and he had given his quarter to the petitioner with common voice for daughter, but after marriage petitioner refused to vacate the quarter thereafter. He had taken help from the department as well from the administration to vacate his quarter and had also made written complaint to DCSP Dhanbad through peaceful, but petitioner did not vacate his quarter. She filed this case and fabricated case only to grab money from him. Respondent has also stated petitioner was earlier married with one Ramanan Paswan with whom she got divorced. In support of her contention, respondent has also filed CC of ordership passed in Itna Exhibit D, CC of plaint of TMS Exhibit E, CC of deposition of Seema Devi and Ramanan Paswan in TMS Itna. On going through the said document, it appears that TMS number was filed by plaintiff Seema Devi.
So, Seema Devi is the petitioner?
Yes, ma'am.
Yes.
She was
a married lady.
She was earlier married to Ramanand Prasad. No
Divorced
doubt
only in 1999.
And decree of divorce in that case admittedly has been passed on 29 1 and 1999. No disputes. And the date of marriage of the petitioner and the respondent is sometime in 1995. It is also not in dispute. But the Honorable Supreme Court in number of cases, and I would like to specifically point a case in which similar set of facts were there. I will first place the facts. Para 3.1. Late Subedhar Bhave was enrolled in the army in the year 1960. On 7 July 1972, he got married to one Srimati Parvati, who died about 2.5 years. Thereafter, the deceased got married to one Srimati Anushya. During the subsistence of his marriage with Anushya, he married appellant number 1 here. Appellants 2 and 3 are the offspring of the deceased, and appellant number 1. On 25th January 1984, the deceased was discharged from service at his request and was granted service pension at the rate of itna per month. On 15 November 1990, the deceased Anushya granted a decree of divorce by mutual consent, and he paid a lump sum amount of 15,000 to her. Thereafter, the deceased approached the respondent number 2 for deleting the name of Anushya and endorsing the name of appellant number 1 in the PP. He also submitted certificate issued by the village Sarpanch Gram Panchayat certifying that he and the
No,
appellant.
what do you want to? You will read the entire judgment. What do you want to say?
Only 2 more paragraphs.
No, what do you want to say?
I just
by
want to
citing
say
this
that there is a period of long cohabitation which has not been considered by the trial court at any point of time. The and same sets of circumstances were in this case.
No. The second marriage was proved.
Second marriage.
Was it proved in this case that
Yes,
there
my
was
lady. Yes, my lady. It has
that
been
there was a
proved.
marriage during the subsistence of first marriage?
The long cohabitation has been.
That's right. But here in your case, it is ex facie apparent from the records that you claimed that there was a marriage you claimed in 1995.
Yes,
The
ma'am.
divorce with your first husband happened only in 1990.
Yes, my lady.
So on the day you claimed marriage, right?
Yes, my lady.
You were not a legally wedded wife. The matter ends.
My lady,
When there is a clear proof,
when the long cohabitation is seen, just the
we
long
will not
cohabitation.
permit this.
पैरा एक बार इनका जो डेपोजिशन है बस वो देख लें.
डिपोजिशन से कोई मतलब नहीं है. आप हमको इतना बता दीजिए.
पर्विसिटी ऑफ ऑर्डर में बस इतना है कि जो फोटोग्राफ्स है वो 65B को कंफर्म नहीं कर रहा.
कोई जरूरत नहीं है. ये एविडेंस क्या बता रहा है आपका?
एविडेंस हम
1995 का शादी का बाद कौन बताया है? आपका विटनेस है? किनका विटनेस?
वो कॉमन विटनेस ही लोग बता रहे हैं. दोनों का बता रहे हैं.
दोनों का विटनेस कभी होता है क्या?
नहीं, मतलब मेरा भी बताया है और इनका भी बताया
बताया है ना. 95 का शादी.
95 का
डिवोर्स कब हुआ?
मेरा डाइवोर्स हुआ है
99 में. और आपने अपना नलिटी वाला पिटीशन कब फाइल किया?
मैंने वो
97 में.
97
बस बात खत्म.
एक मिनट देख लिया जाए. इसमें जो वृंदा प्रसाद का जो डेपोजिशन में आया है क्रॉस एग्जामिनेशन में, इसमें है कि साक्षी की अविदिका पुत्री की शादी के साथ फोटो दिखाया गया.
Photo, you forget about the photo. How does that make a difference?
It is very relevant. If it is not relevant, I won't place it. दिखाया गया जिसमें विपक्षी का स्वयं का होना स्वीकार किया गया, जिसमें वो apparently कन्यादान कर रहे हैं. इसीलिए ये relevant.
कौन कन्यादान कर?
The petitioner and the respondent are कन्यादान कर रहे हैं इनकी बेटी का. That is a valid proof. That is a valid.
दो आदमी मिलके एक बच्चे का कन्यादान कर रहे हैं. That becomes a valid proof of those two persons of marriage.
कन्यादान कर रहे हैं और इसमें एग्जिबिट में और भी है कि जैसे दोनों अपना जॉइंट पासबुक है दोनों का.
It has got no relevance.
जॉइंट पासबुक है. देन जो टाटा कोल्ड्री में डिपेंडेंट का कार्ड है उसमें पिटिशनर का नाम है. हम इसीलिए ये जजमेंट जो है एक बार इसको पूरा प्लेस कर देते हैं. जस्ट टू माय satisfaction. Subedhar Bhave expired in the year I'm reading 3.2. Expired in the year 2000. Thereafter, appellant number 1.
ये फिर से आप पढ़ना शुरू कर दिया. आधा तो पढ़ चुके थे.
हाँ 3.
आपको लग रहा नहीं पढ़े क्या आप? हाँ
नहीं हम पूरा नहीं पढ़े.
आप यहाँ तक तो पढ़ लिए.
3.1 ही पढ़े थे. हम 3.2 पढ़ रहे हैं. Subedhar Bhave expired in the year 2001. Thereafter, appellant number 1 approved the respondents for grant of family pension. The said request was, however, rejected by the respondents on the ground that the deceased had got divorced in 1990, whereas the appellant number 1 claimed to have got him married in February 1981. This is analogous to the facts of this case. That is during the subsistence of earlier marriage. Now straight away, my lady, I will come to para 19 and para 21 of this judgment. Para 19 says, in citing the above said decision and relying on section 114 of the Evidence Act, this court held that in facts of the said case, there was a presumption of marriage between the parents of the plaintiff on the ground of their long cohabitation status, entitling their offspring to claim their share in the suit schedule property. And para 21, my lady. In the instant case, if the period up to the year 1990 was to be excluded as the marriage between late Subedar Bhave and Anushya and had got dissolved on 15 November 1990, the fact remains even thereafter the deceased has continued to cohabit with the appellant number 1 for 11 long years till his demise in the year 2001. The appellant number 1 was the mother of 2 children born from the relationship between the deceased, namely appellants number 2 and 3. Appellants 2 and 3 have been entitled to the estate of the deceased by virtue of the order passed by the High Court on the review. In the above background, a presumption ought to have been drawn in favor of the validity of marriage between the deceased and the appellant number 1, more so when during his lifetime deceased had approached the respondent authorities for seeking deletion of the name of his previous wife Anushya from the service record and for endorsement of the name of appellant number 1, wherein which has been duly acted upon by respondents by letter dated 5th July 1999. It is also not in dispute that ex-wife did not claim any pension from the respondent on the demise of Subedar Bhave. So in this case, my lady, there has a similar set of circumstances where the earlier marriage was in subsistence. The lady had married Subedar, and the Honorable Apex Court had considered the long cohabitation status of the petitioner there. And my lady, also one judgment of the coordinate bench, my lady, para 10, I would just like to place that in a.
We will continue tomorrow. It is already 1:30.
Tomorrow, my lady, I have some personal difficulty. If it can be taken up day after.
Counsel for the parties are present. The matter was being argued at length by the counsel for the petitioner. However, the hearing has remained inconclusive as the court time is over. Pose this case for further hearing on day after. So, day after tomorrow, 1 o'clock.